You took 11 years of my life away. You said at least I didn't kill you.
How can a man, especially a man trained in law enforcement, lose his temper to the point of killing the mother of 9 children?
I can't even remember the names of all the little children that have been killed. One of those kids could have been killed too. It doesn't take a bullet to kill somebody.
Jacob Kudla and Jordan Babish from Westland, Michigan, set out for Detroit one summer day in 2012. They had plans to meet someone in the city, but never returned home. As hours turned into days, their families grew increasingly anxious. After 5 days of searching, a heartbreaking discovery was made. Their bodies were found in an abandoned field on Detroit's east side. Evidence led police to Frederick Young, 26, from Detroit, and Philando Hunter, 24, from Jackson. Investigators learned that Kudla and Babish had gone to a house in Detroit to buy drugs, where they encountered Young and Hunter. What began as a simple meeting took a dark turn when the 2 men robbed them. The boys were then taken to a vacant lot, where their lives were tragically cut short. When the trial began, emotions ran high in the courtroom. The mothers of Kudla and Babish shared their grief, speaking about the unbearable pain of losing their sons.
Jacob was my only son. He was murdered when he was 18 years old. My son had been barely shaving. He was my only child. Not only did the defendant take away my son's future, he took away my future. My future as a mother, my future as a grandmother.
The 2 defendants have taken away so many milestones from him. He was 2 months shy of his 18th birthday, proving to his parents that he could graduate high school, drinking his first beer at the age of 21 with his brother at a bar to celebrate his birthday, finding the love of his life, his wedding day, seeing his first child born, and so many more.
Jordan Babish's loved ones spoke from the heart. They acknowledged the difficulty of forgiveness, but believed Jordan would have wanted compassion, even in the face of unimaginable loss.
I love you, Jordan Michael Babish, to infinity and beyond, and I wish to carry the weight of your burdens on my shoulders so that you may rest in peace.
In the end, knowing who Jordan was, I believe he would want me to offer forgiveness. Although I know I may struggle with that endeavor for the rest of my life, it would be what Jordan would want. And know that as I read this today in the courtroom, Jordan was standing next to me. On behalf of Jordan and myself, I will pray for forgiveness for both of you.
Then came the moment of sentencing. The courtroom fell silent as Young and Hunter stood before the judge.
I'd like to say sorry to the families of Ayanna Jones, Michael Brown, Eric Gardner, and I want to apologize to them for not being able to get justice for their loved ones who was murdered in cold blood. And in respect for the peaceful protest, I want to say hands up, don't shoot.
Young, instead of addressing the families of Kudla and Babish, chose to speak about the deaths of Ayanna Jones, Michael Brown, and Eric Garner, individuals who had lost their lives in high-profile incidents involving law enforcement.
Do you have anything to say, sir?
Hunter, on the other hand, remained silent. Both Hunter and Young were sentenced to life in prison. Though the verdict brought a sense of justice, it could never undo the loss. Philip Seidel and Tamara Wilson Seidel, parents of 9, had spent 24 years together in a turbulent marriage, marked by control and mistreatment. When their divorce was finalized, their sons and daughters hoped for peace, but their father's anger had not faded. Just weeks after the separation, his rage erupted into an irreversible tragedy. On a summer day in 2015, Seidel followed Tamara as she drove through Asbury Park, New Jersey. In a fit of anger, he rammed his car into hers, forcing her to stop. Inside his vehicle, their daughter, Teresa, sat frozen in fear. Seidel fired the shots, ending Tamara's life in broad daylight. The shooting sent shockwaves through the community. A former Neptune Township police sergeant, Seidel was expected to uphold the law, yet he had betrayed the very principles he once swore to protect. In court, Seidel admitted to the crime, but attempted to justify his actions.
I was struggling with something that I had a great deal of difficulty dealing with, and I simply snapped. I just want the court to understand that that was not me.
He then turned to his sons and daughter, offering a hollow apology.
I'm sorry. I'm sorry.
His words carried no weight. His sons and daughter, refusing to meet his gaze, rejected his remorse. They spoke of the years of fear and abuse their mother endured, and how he had taken her life just weeks after the divorce was finalized. Philip Seidler Jr. addressed the court.
I cannot bear to see his image. I'm embarrassed to share his name.
His sister, Kirsten, stood before the court, directing her grief and anger at her father.
To this day, we still don't understand why. How can a man especially a man trained in law enforcement, lose his temper to the point of the mother of 9 children.
Originally charged with murder, Seidel accepted a plea deal, reducing the charge to aggravated manslaughter. Prosecutors believed this was the best way to deliver justice while sparing his sons and daughter from the trauma of a lengthy trial.
We feel that justice was served under the circumstances, and we can only hope that his last days on earth will be behind bars.
When the judge delivered the sentence, Seidel was ordered to serve 30 years in prison, with at least 85% of his term required before parole eligibility. His earliest possible release date was set for 2041. Michelle Knight disappeared after accepting a ride from Ariel Castro, a man she knew through a friend. Instead of reaching her destination, she was trapped in his home for 11 years, isolated from the world, and led to believe that no one was looking for her. Over time, Amanda Berry and Gina DeJesus were also taken captive, and together, they endured years of hardship. Despite the darkness, Michelle and Gina formed a deep bond, supporting each other through the pain. Their ordeal finally ended when Amanda Berry escaped and called for help, leading to their rescue and Castro's arrest. At his sentencing, Michelle confronted Castro with strength and determination, declaring that she would heal while he would face the consequences of his actions. She spoke first of her son, the boy she had been torn away from when she was kidnapped.
I miss my son every day. I wonder if I was ever going to see him again. He was only 2.5 years old when I was taken. I look inside my heart and I see my son. I cried every night. I was so alone. I worried about what would happen to me and the other girls every day. Days never got shorter. Days turns into nights. Nights turns into days. Years turned into eternity. I knew nobody cared about me. He told me that my family didn't care. He tormented me constantly, even on holidays. Christmas was the most traumatic day because I never got to spend it with my son. Nobody should ever have to go through what I went through, or anybody else, not even a worstest enemy.
Despite the suffering, she found strength in friendship. Gina DeJesus, another victim, became her support.
Gina was my teammate. She never let me fall. I never let her fall. She nursed me back to health when I was dying from his abuse. My friendship with her is the only thing that was good out of this situation. We said we will someday make it out alive, and we did.
Turning her focus to Castro, she reminded him of his hypocrisy and how he thought of himself as a good person.
Ariel Castro, I remember all the times that you came home talking about what everybody else did wrong and act like you wasn't doing the same thing. You said, at least I didn't kill you. For you took 11 years of my life away, and I have got it back. I spent 11 years in hell. Now your hell is just beginning. I will overcome all this that happened, but you will face hell for eternity. From this moment on, I will not let you define me or affect who I am. You will live, I will live on. You will die a little every day. As you think about the 11 years and atrocities you could inflict it on us. What does God think of you hypocritically going to church every Sunday, coming home to torture us?
She vowed that while she would overcome the horrors of her past, he would spend every day reliving the atrocities he had inflicted.
The death penalty will be so much easier. You don't deserve that. You deserve to spend life in prison. I can forgive you, but I'll never forget. With the guidance of God, I will prevail and help others that suffered at the hands of others. Writing this statement gave gave me the strength to be a stronger woman and know that there's more good than evil.
Castro accepted a plea deal to avoid the death penalty. He pleaded guilty to aggravated murder, kidnapping, rape, and other charges, receiving a life sentence plus 1,000 years without the possibility of parole, but died in his cell less than a month later. Reginald Rose Robinson, a student at Garden City High School, was shot and killed on February 24, 2017 on Myers Street on Detroit's west side. That day, Robinson entered the store where he encountered 21-year-old Sharnea Diamond McCoy and 25-year-old Erica Italy Osborne. Witnesses later reported that Robinson had laughed after someone commented on the two women. Though the moment seemed insignificant, it quickly escalated into something more serious. Surveillance footage later revealed that after the exchange, McCoy got into her blue Ford Explorer and made a U-turn outside the store, positioning the vehicle so her passenger, Osborne, could aim. Moments later, a shot was fired, ending Robinson's life.
She's seen on surveillance video driving her blue Ford Explorer and doing a U-turn to put the car in a position where her passenger could take aim.
Police launched an investigation, gathering evidence that pointed directly to McCoy and Osborne. Both were arrested. In court, Robinson's family faced the painful reality of his loss as they awaited justice. His mother, overcome with grief, addressed McCoy first, speaking of the unbearable pain she carried every day.
Every time I would close my eyes, I would see my son laying on that cold ground in a puddle of blood.
Then, turning to Osborne, she expressed her anger and devastation.
You are rotten to the core, and you are sickening to my stomach as well as the city. You should be under the jail.
Before their sentencing, both McCoy and Osborne offered brief statements of regret.
I just wanted to make sure that the family knows that I am sorry. I apologize for my actions, whether you accept it or not, I apologize for my actions.
However, their words did little to ease the family's sorrow. As part of their plea deals, McCoy and Osborne pleaded guilty to second-degree murders and felony firearm violations. McCoy was sentenced to 16 to 40 years in prison, while Osborne received 27 to 50 years. Suge Knight, once a powerful figure in the music industry, found himself in a courtroom, awaiting sentencing for a tragic incident that claimed the life of Terry Carter and left Clee Bone Sloan injured. The events unfolded outside a burger drive-thru in South Los Angeles after an argument on a commercial set for the film Straight Outta Compton escalated. Knight, behind the wheel of his Ford pickup, struck both men. During the hearing, Carter's family delivered emotional statements, expressing their grief and anger. One family member described Knight's actions as calculated, deplorable, and showing no respect for human life.
Your actions after you callously murdered my dad in cold blood were calculating and deplorable and reflective of a lack of moral character and no respect for human lives. Those of a low-life thug, career-minded criminal, three-striker with a reputation of being a murderer. What I do know is that your unrepentant, remorseful, callous, unashamed actions took my dad's life away. My dad's last moments of life were blasted all over TV, the internet, social media. He is truly a disgusting, selfless disgrace to human decency.
They spoke of the pain of losing their loved one and the added trauma of seeing his final moments shared widely across TV, the internet, and social media. Knight, who had pleaded no contest to voluntary manslaughter, listened as the judge reviewed his case.
For the crime which the defendant has been convicted in count 1, a violation of Penal Code Section 192, Subdivision A, voluntary manslaughter with the strike prior conviction having been found true, defendant is sentenced to state prison for the high term. The reason for the high term is as a condition of the plea bargain. The high term is 11 years and must be doubled under the strike law. Defendant is levied a term in state prison of 22 years. Pursuant to Penal Code Section 12022, Subdivision B, Subdivision 1, he is levied an additional and consecutive 1 year in state prison. Pursuant to Penal Code Section 667, Subdivision A, Subdivision 1, the prior conviction the defendant has admitted, he is levied an additional 5 years in state prison for a total unstayed term of 28 years. This time, defendant is ordered transferred to Department 120 to have a dismissal on the other matter, which is part of this plea bargain. If there's nothing further, that'll be it. Thank you, Your Honor.
Given his previous criminal record, his sentence was enhanced under California's 3 strikes law. In the final ruling, Knight was sentenced to 28 years in prison, a combination of time for the manslaughter charge and additional penalties linked to prior convictions. With the sentence handed down, Knight was ordered to state prison, bringing closure to a case that had drawn national attention. For Carter's family, no verdict could undo their loss, but they hoped justice had been served. Kalia Harris's case began with a troubling series of events at a playground, where a girl, the daughter of Joyce Swan, had been bullied for weeks. The situation escalated into a fight, and instead of intervening, Harris stood by and allowed it to continue. Surveillance footage captured her in action. Witnesses later recalled her response. She simply did not care. When Swan arrived at the scene, she was desperate to understand what had happened to her daughter. But instead of an explanation, she was met with hostility. The incident led to Harris's arrest and legal proceedings. She was charged with inciting violence, a third-degree felony, along with contributing to unruliness and delinquency.
This defendant pled guilty to inciting to violence, felony 3, contributing to unruliness or delinquency. Mr. Moriarty, have you been given the opportunity to review the pre-sentence investigation report?
A person who lives under tremendous pressure, a single mother, living in a very dangerous part of Cleveland. She navigates through daily fights that she sees.
As the case progressed, the prosecution provided insight into Harris's background, describing the pressures she faced as a single mother in a high-crime area of Cleveland. However, the court's focus remained on her actions that day. During her sentencing, Harris was given a chance to speak.
I just want to apologize to the children first. I also apologize to Ms. Swan for my actions and not taking a better judgment instead of putting myself into this whole situation. I know that I was completely wrong, and I just hope that everyone accepts my apology.
She acknowledged her mistakes and expressed regret, hoping for forgiveness. Swan, however, was not convinced. She reminded the court of Harris's indifference at the time.
The day of the fight, Kalia didn't show no remorse at all. In the video, people was telling her, why'd you letting them little kids fight them? Why'd you letting the big kids fight the little girl? And she said she didn't care. When I got there, Kalia wanted to fight me. I wanted to just find out what was going on. I just had left my daughters, literally. These little girls stalked my daughter for 2 weeks before they fought her. They was bullying her at the playground.
How old is your daughter?
She's 12.
The judge addressed the seriousness of the situation, speaking on the increasing violence among young people.
How can we expect these young kids to grow up and be law-abiding citizens if their parents can't be? We have funeral after funeral after funeral here. I can't even remember the names of all the little children that have been killed. And you know what? One of those kids could have been killed too. It doesn't take a bullet to kill somebody. Maybe faster, maybe neater, but it doesn't take a bullet. This court is going to sentence you to 18 months at Ohio State Reformatory for Women on count 1, 120 days on count 4 and count 5. All counts, of course, will run concurrent.
The court then delivered its verdict. Harris was sentenced to 18 months at the Ohio State Reformatory for Women for inciting violence, along with 12 days for contributing to unruliness and delinquency, with the sentences to run concurrently. Sherdavia Jenkins was a bright and talented girl who lived in Miami's Liberty Square housing projects. She was known for her exceptional intelligence, achieving the highest FCAT scores in her class, and becoming a chess champion. Her promising future was tragically cut short on July 1st, 2006.
But some of the things we've learned about Sherdavia is she wasn't your average 9-year-old. She had a promising future. She had the highest FCAT scores in her class. She was a chess champion at the age of 5. She was a unique and special little girl, and her life has been forever silenced. This has affected the community. This has affected her brothers and sisters, her parents, as you've seen and heard today.
That afternoon, she was playing on her front porch when a gunfight erupted between Damon Red Rock Darling and Leroy LaRose. The two men, caught in a violent altercation, fired recklessly in broad daylight. A stray bullet struck Sherdavia, and she collapsed in her mother's arms. In the wake of her death, the community came together to honor her memory. Across from the housing complex where she was killed, the city established the Sherdavia Jenkins Peace Park. It stood as both a sanctuary for boys and girls and a somber reminder of the consequences of unchecked violence. Her family and loved ones gathered there every year, marking her birthday and the day she was taken, turning their grief into a call for change. The legal process took several years before those responsible were held accountable. In September 2009, Leroy LaRose took a plea deal, admitting guilt to second-degree murder in exchange for a 7-year sentence. As part of the agreement, he testified against Damon Darling, who was later found guilty of manslaughter and possession of a deadly weapon.
That's the way I feel. But whatever the sentence, whatever the outcome, I forgive him. I just can't forget what he done.
Madam Clerk, would you please publish the verdict?
Will the defendant please rise?
During the trial, the prosecution emphasized the recklessness of firing in a residential area where people were playing. Darling, a convicted felon on probation at the time of the shooting, displayed a pattern of violent behavior that ultimately led to Sherdavia's death.
And this defendant is unique for many reasons. The court knows just by the court files that he was on probation at the time of this offense, that he was a convicted felon at the time of this offense, as was noted during the trial. And the jury has found him guilty of manslaughter with the enhancement of the firearm. Judge, this is the type of case that you look at the facts and you look at a person that's brazen enough to fire an AK-47 at 3 o'clock in the afternoon in a residential neighborhood while children are playing. And you wonder, can the community ever be safe with him being out there again?
At the sentencing, the weight of the tragedy was felt throughout the courtroom.
What happened to Sherdavia just ripped my family apart. It ripped me apart.
I was there and I saw. My daughter Catherine, she saw. My 8-year-old, when it happened, he was 4. How could you explain to a 4-year-old his sister was never coming back? You can't.
Sherdavia's family spoke of their heartbreak, the unimaginable pain of losing her daughter, and the lasting impact on her young siblings. One of the siblings had witnessed the horrific event. The defense emphasized that the defendant accepted responsibility for his actions, while also arguing that he initially believed he was acting in self-defense when he saw someone approaching him with a gun.
He's sorry for what he did. He's sorry for what he thought was a self-defense when somebody was coming towards him with a gun. The jury found otherwise, and he accepts their decision, and he asked you to sentence him. He's willing to step up and take his responsibility like a man.
They claimed that Damon Darling regretted what had happened, but the jury ultimately rejected this argument, finding him guilty of manslaughter.
The nature of the crime and the weapon of choice here, which you, sir, chose as an AK-47, probably the most dangerous type of weapon. You as a felon on probation at a young age made the choice to continue in a pattern of activity that ultimately led to the senseless death of an innocent child. You terrorized a neighborhood, sir. Your reckless action and your negligent action showed a total disregard for anyone, and it was selfish. It was a selfish, violent act. Nothing I can do to punish you really is going to minimize the pain and the suffering you caused to the family of the dead child, and also to your own family, because they've lost a child, and your family is essentially, by the time you're going to be serving in prison, they are losing a child. And there's sympathy to them as well. For you, sir, I have no particular sympathy. And therefore, the court, in accordance with the statute, is going to sentence you as to count 1. The maximum penalty, counsel, is 30 years?
30 years.
30 years Florida State Prison. And as to count 2, 20 years minimum mandatory Florida State Prison. That sentence will be consecutive.
The judge condemned Darling's disregard for human life, acknowledging the suffering his actions had caused. While sympathy was extended to his family, who would now lose him to the prison system, the court made it clear that the man responsible for Sherdavia's death deserved no leniency. He was sentenced to 30 years in Florida State Prison for manslaughter and an additional 20 years for possession of a deadly weapon, to be served consecutively.
I can't bring her back, but I'm satisfied. It was the max. Yes. I mean, the anticipation it overwhelmed me. I didn't sleep last night for the anticipation of this day. And I think justice was served.
Though no punishment could bring Sherdavia back, the sentencing provided a measure of justice. Her family found some solace in knowing that the person who had stolen her life would spend decades behind bars. In early October 2019, the small town of Pelham, New Hampshire, was shaken by the tragic death of Luis Garcia, a well-respected pastor at the New England Pentecostal Ministries Church. He was found deceased in his home under suspicious circumstances. Soon after, police arrested 24-year-old Brandon Castiglione, the son of Mark Castiglione. Authorities charged him with second-degree murder, though the motive remained unclear. Just 11 days later, on October 12, 2019, the church was preparing for a joyous occasion, a wedding between Mark Castiglione and Claire McMullen. The congregation gathered in the place where they had often come for comfort and prayer, unaware that the events of that day would unfold in a way no one could have predicted. As the ceremony was underway, 37-year-old Dale Holloway entered the church. Moments later, a sudden commotion broke out, causing panic among the attendees. Bishop Stanley Choate, who was officiating the wedding, was seriously hurt, while the bride, Claire McMullen, also sustained an injury. Mark Castiglione was physically assaulted in the altercation, leaving him injured as well. The chaotic scene left guests scrambling for safety as some rushed to help the wounded. Fortunately, first responders arrived swiftly and all the injured individuals were transported to the hospital for treatment. Holloway was detained at the scene and taken into custody. Authorities wasted no time in charging him with multiple offenses, including attempted murder, first-degree assault, and being in possession of a firearm as a convicted felon. Due to the severity of the case, the court ruled that he would remain in custody without bail while awaiting trial. In the long legal battle that followed, Holloway repeatedly sought to delay court proceedings. On June 28, 2021, he formally requested a trial postponement, arguing that he needed more time to prepare and had concerns about his legal representation. He claimed that the defense team assigned to him was not adequately representing his interests.
Of Attorney Lee, if he accepts the appointment and is appointed by the Judicial Council to represent Mr. Holloway. I want to make sure that the roles are well defined in terms of what Attorney Lee will be responsible for and what he will not be responsible for in this case. As we were proceeding with that hearing, Mr. Holloway made a request that this trial be extended out 6 months in terms of motions deadlines, the TMC, the jury trial conference, and the actual jury trial. He's making that request under his view that he's going to need significant time to get prepared as a self-represented litigant. I can have him file a formal motion to continue if you want. I don't know if you have any initial reaction to that motion to continue.
The state strenuously objects. The victim has waited long enough for justice, and the state wishes to proceed in September. Mr. Holloway's been doing this from the jump. He's had all this information since he fired attorneys Brown and Lee, and there's no need for any further continuance. He has plenty of time to file whatever he wants to.
Mr. Holloway, I think the best way to handle this now is that you file a motion to continue and extend the various pleading deadlines. And then Attorney Devine will have 10 days to respond to that. And I expect that I may well have a hearing on it, and we could coordinate that with your hearing on the hearing for standby counsel. I don't think it does us any good to argue it now. I want to give you time to prepare and give me your exact reasons in writing, and then you can support them at a hearing. And then likewise with Attorney Devine, she can specifically respond to your motion. We can have a hearing, and I can make an informed and meaningful decision as to whether to extend the trial date and all the accompanying deadlines. When do you think you can get that motion filed by, sir?
Currently, I'm pretty much currently restricted, which is the reason why I'm asking for a continuance. I haven't been able to order commissary. I've been in the state prisons for 30 days now, and I still can't order a book of stamps. I just got my property maybe a day ago. I just sorted out all of my papers. I'm not really sure exactly when I'll be able to mail a letter out, Your Honor, but I will try to make it happen, and I will try to file a continuance motion as soon as possible. That's pretty much what I was asking for, continuance based on those facts.
All right, very good. So what I'll do, just to make sure we stay on top of that, is I'm going to schedule a hearing on your request for a continuance today, along with a hearing on the specific definition of the role of standby counsel in this case. And we'll schedule that about 2 weeks out, so we can stay both on top of your request for a continuance as well as standby counsel, because you'll have a need for that for obvious reasons in this case. So we'll schedule the hearing out. Hopefully, if your situation allows it at the prison, you can put it in black and white in terms of your reasons for the motions to continue, so that I can get a response in writing by the state, and then we can have a hearing on that. But I'm going to schedule the hearing now so we keep things going.
Thank you, Your Honor.
All right?
Thank you, Your Honor.
You're welcome, Mr. Holloway. Do you want to do that now, Jackie, or wait and take a look at the schedule?
I can do that now, Judge. Can we transport?
All right, very good. Mr. Holloway, we're going to transport you for that hearing because it's very difficult to set up the WebEx.
Okay.
Within that.
However, prosecutors strongly opposed this request, asserting that the case had already seen significant delays and that further postponement would hinder justice for the victims. Despite Holloway's arguments, the court ultimately ruled against granting additional delays, ensuring that the trial would move forward. Over the next 2 years, Holloway's behavior in custody raised further concerns. In November 2021, he got into a physical altercation with his attorney, resulting in additional charges.
Having said that, I am going to sentence you consistent with the state's recommendation. You've already done, I think, 4 sentences. The last 2, a 4.5 year or 4 to 7. In each of those cases, there was probation and parole. And so I think whatever you need to do behind bars, because it obviously didn't work in our community. The explanation that you give, I believe it's genuine. You told me about this during a hearing, that you acted out of fear, and that you believed when Attorney Davido came to see you that he was somehow part of this system that was going to get you. But that is a belief that is so unattached to reality that it's kind of scary that you would react in this way, even if you believe something like that. I look at Attorney Davido and I find somebody believing he could be a threat is just so off the mark that it's hard to even get my head around how that could be. But my head's not your head, my experiences aren't your experiences. But if that's what triggered this, then something very small can trigger this kind of behavior. For a family to say things like, I was worried that Michael would die, is not something that people should have to live with. So with that said, I'm going to adopt the state sentence. The sentence is to the New Hampshire State Prison for not more than 7 years, nor less than 3.5 years. There is a pretrial confinement credit of 584 days. The sentence sheet that you submitted is up to 6 years, 3 to 6 years. I don't think that's what you intended. Is that right?
Your Honor, the state sentencing sheet was the 7.5 to 15.
Yes, that's what I thought. Oh, did the defense submit it? No?
The defense did submit a 3 to 6 proposed
I
sheet
see.
as well.
Okay, I did pull up the wrong one. Okay, that's why I was looking at you confused. Okay. Yep, so I apologize. So it is a sentence to the New Hampshire State Prison of not more than 15 years, no less than 7.5 years. There's pretrial confinement credit of 584 days. There's added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the sentence. The sentence starts immediately.
He was convicted for this incident and sentenced to an additional 7.5 to 15 years in prison. By October 2023, after years of legal proceedings, his trial for the church incident finally began. Holloway decided to represent himself in court, arguing that he was not mentally stable at the time of the event. However, after reviewing the evidence and hearing witness testimonies, the jury was not convinced.
Do you find by clear and convincing evidence that the defendant was insane at the time he committed the criminal acts on October 2nd, 2019? Yes or no?
No. We all been devastated by this. It's been a traumatizing situation. And now we're going to say bye-bye. That's right.
Holloway's attorney said that he was grieving at the time of shooting, which impaired his judgment.
Are there people out there who truly suffer from mental disease and defect, and their actions are the result of a mental disease or defect? Yes. Mr. Holloway is not one of those people.
In November 2023, they found him guilty of attempted murder, multiple assault charges, and unlawful possession of a firearm. Finally, on January 29, 2024, the sentencing took place. The judge handed down a 40 years to life prison sentence. Holloway declined to be present for the hearing. With the case officially closed, the victims and their families were left to process the events that had shaken their community. In the early hours of July 13th, 2024, the town of Willoughby, Ohio, experienced a heartbreaking incident. Rogelio Cabrera, a high school student and part-time roofer from Madison, was found injured in an alley near a local restaurant on Erie Street. Known for his kind nature and positive influence, he had built strong connections within his community. At around 12:30 a.m., a disturbance was reported to the police, with witnesses describing a commotion and a person leaving the area. When officers arrived, they found Cabrera in critical condition. Despite immediate efforts to help him, he did not survive. As authorities began their investigation, witness statements and security footage led them to identify 23-year-old Fernando Alejo from Painesville as a person of interest. It was revealed that he and Cabrera were not strangers. They had worked together in roofing and had shared a friendship for about a year. The news of his involvement left Cabrera's family struggling to understand what had happened. Later that morning, at around 10 a.m., Alejo was stopped by Indiana State Police while traveling along the Indiana Toll Road. Reports indicated that he was on his way to visit family in Chicago when he was taken into custody without incident. A few days later, on July 16th, Alejo appeared before a judge in Willoughby Municipal Court for his arraignment. Given the circumstances surrounding his arrest, the judge denied bail, citing the seriousness of the case. The matter was then transferred to a Lake County grand jury for further review. In September 2024, the grand jury issued a formal indictment, moving the case forward to trial. By January 23, 2025, Alejo was back in court for a plea hearing.
Defendants in court represented by Attorney Dustin Blake. The state of Ohio is represented by Assistant Prosecuting Attorneys Adam Downing and Rachel Wood. We are here today for purposes of a tentative change of plea. It's not to intimate that the plea was ever forthcoming, but if the state would put the offer, if any, on the record.
Thank you, Your Honor. As discovery is being exchanged in this process early on in about November, December, I did have a number of conversations with Mr. Blake regarding a potential resolution of this case. Initially, the state did not make any formal offer. Mr. Blake and I, through our conversations it was proposed the possibility of the state offering a charge that was a departure from the murder being some sort of manslaughter charge. After discussing this with the family and discussing it with our office, the state ultimately decided not to extend any offer that it's a departure from the murder. The state did verbally convey to Mr. Blake that the state would be willing to offer a plea of guilty to the murder charge as a standalone charge and dismissing counts 1 and 3. But my understanding is through the verbal negotiations that we had that the charge of murder was a non-starter for defense counsel and his client. So the state never officially made that offer, but we did have extensive plea negotiations regarding that. So there's no offer that the state necessarily presented that the defendant is denying, but nonetheless, it's my understanding there is no resolution on this case and that it will proceed to trial.
And then as far as count 2, that would be with both the firearm specification, which is a 3-year and the forfeiture specification.
Correct.
Very good, thank you. Blake, does that adequately reflect the status of any negotiations?
Yes, Your Honor. Just like in any criminal case, we had discussions regarding plea negotiations. Ultimately, we were not able to reach a resolution.
Very good, thank you. We did have an opportunity to discuss outstanding matters in this case prior to coming on the record. Some discovery issues that have come up based on those discovery issues. Is it your intention in the near future, Mr. Blake, to file a written motion to continue the trial date, which is currently set for February 10th?
That's correct, Your Honor. I can do that later today, or if not tomorrow at the latest.
And just to be clear, if your client did sign an indefinite time waiver on this matter?
That is correct, Your Honor.
If that is forthcoming, would the state have any objection to continuing the trial date?
Your Honor, given the recent developments and the issues regarding the discovery of new evidence that we discussed, I don't believe the state is in a position to object to that continuance.
Despite discussions between the defense and prosecution, he maintained his not guilty plea, leading to preparations for trial. During the hearings, several legal matters were addressed, including how digital evidence such as videos and photos would be presented.
Your Honor, I did want to put some of the items we discussed in chambers on the record. I won't go as into detail as we did on the record, but just a number of things. The state did discuss a procedure for the introduction of evidence in this case, which is a change from how the state has done in the past, where the state will be providing digital solid-state drives to present all of the non-physical items, meaning the videos, the photographs, and any documents, and the procedure for doing that. The state has researched this extensively and believes that there is a reliable way to do this using multiple drives and doing it on the record and doing it by hashing the items to ensure that they are accurate. We discussed those details in court. The state's still going to work out some procedures, but I did discuss that. The state also discussed the use of a demonstrative exhibit in trial being a blue gun, which is a 3D printed model of the firearm in this case. The firearm in this case was an FN 509. The dimensions of that firearm, which are a 9mm pistol, are very similar to a Glock 23, which is what the state has 3D printed. I did discuss the possibility of using that in trial and whether defense counsel would be okay using the Glock 23 model or whether defense counsel would want the exact 509 3D printed. And Mr. Blake indicated that he would get back to me on that. And
now as to the actual firearm that is allegedly used in this matter, that will be here, but you're talking about anyone who's handling it in the courtroom, attorneys, witnesses?
That is correct, just so that we don't have a firearm, an actual firearm being handled by many people. That firearm, our intention is to keep it locked at all pertinent times and to have to keep unlocking and locking the child lock to use it, and it would take a lot of time and it does present a safety issue. The state, I did discuss the stipulations. The state also, we discussed in chambers, the coroners in this case, Dr. Gilson, the Cuyahoga County coroner who performed the autopsy, and Dr. Keep, the Lake County coroner who ultimately signed the death certificate. I discussed in chambers that the state emailed defense counsel on January 19th, clarifying that both of those coroners will be testifying. Dr. Gilson will be testifying about the autopsy, Dr. Keep will be testifying about the ultimate death certificate, and that in this case there were 2 gunshots. the coroners are unable to say with any medical certainty which shot occurred first and second, and the state would never ask them that because they're unable to testify to it. However, Dr. Gilson did indicate that the shot to the chest, although would potentially be fatal, would not have instantly been fatal, and that was potentially survivable if the victim had received medical care. Compared to the shot in the head, Dr. Gilson indicated that that shot, based upon the path that the bullet traveled, would have caused instant or near instant loss of consciousness and death. That is based upon Dr. Gilson's medical training. The state did request Dr. Gilson to issue a additional report, in addition to the autopsy report describing just that. Dr. Gilson indicated that that's something that he had been requested to do in the past in other cases, especially in Cleveland and Cuyahoga County, and that he did not believe that he needed to do that it was something within his purview as an expert witness, and based on the autopsy report that he could testify to that. I will note that on the death certificate, there is a notation for cause of death, and next to that, there's a notation for onset of, or interval of time of death between the incident that caused death and death, in this case that being the gunshot, and listed on there as seconds, which is consistent with the gunshot to the head. Based upon those, I let Mr. Blake know about this and indicated that it would be the state's intention to ask the coroners at a trial in this matter to describe the effects that the gunshots would have had, meaning the one to the head caused instant or near instant loss of consciousness and death versus the one in the chest. And I believe that the state can ask that based upon the documents provided. But of course, I know anytime we get into expert witnesses, this is an area of the law that's governed by many rules and cases, and certainly don't want to do anything that's going to cause any problems at trial. So it's an issue that I wanted to give notice to ahead of time outside of the 21 days. And if there is going to be any issue with that testimony at trial, I would like to know that ahead of time so it's not something that is causing an issue in the middle of trial.
The prosecution suggested using solid-state drives instead of physical copies to streamline the process. They also proposed using a 3D printed model of a firearm, similar in design to the one related to the case, as a safer alternative for demonstrations. Additionally, expert witnesses, including medical examiners, were set to testify about the case findings. However, they would not speculate on the order of events leading to Cabrera's injuries. The court also ensured that victim rights protections under Marcy's law were upheld, allowing key witnesses to be present and protected throughout the proceedings. As of March 2025, Alejo remains in custody as the case moves toward trial, with many awaiting the outcome in hopes of closure and justice. In Hollywood, an incident involving Atal Ap Rocky, Rakeem Mayers, and his former friend Terrell Efron, known as Ayal Ap Relly, led to serious legal consequences. Efron alleged that during a dispute in November 2021, Mayers fired a semi-automatic handgun at him, causing a minor hand injury. Months later, on April 20th, 2022, upon returning from a vacation with Rihanna, Mayers was arrested at Los Angeles International Airport by LAPD officers. He was charged with assault with a deadly weapon in connection to the alleged shooting. Bail was set at $550,000, which he posted shortly after. Following his arrest, detectives executed a search warrant at Mayers' residence, but they did not recover the firearm that was allegedly used in the incident. Additionally, the shell casings provided by Efron had no identifiable fingerprints. However, surveillance footage reportedly showed a man resembling Mayers holding what appeared to be a gun. On August 15, 2022, the Los Angeles County District Attorney's Office formally filed charges against Mayers. After a series of preliminary hearings, a judge ruled on November 20, 2023, that the case had enough evidence to proceed to trial. Mayers pleaded not guilty on January 8, 2024, rejecting a plea deal that could have resulted in a 6-month jail sentence. The trial began on January 24, 2025, at the Clara Shortridge Foltz Criminal Justice Justice Center in Los Angeles. The defense argued that the alleged firearm was actually a prop gun that fired blanks, and that Ephron's accusations were financially motivated. The prosecution presented surveillance footage and Ephron's testimony, but inconsistencies in his statements and a lack of concrete physical evidence weakened their case. During the trial, the defense focused on challenging the witness's credibility.
It's fake, you said?
It's fake.
So that's another fake recording.
That's another fake recording.
So that's not your voice?
That's not me. You just said he's an IT guy.
Oh, so who are you talking about?
Your Honor, at this point, there's no foundation. They're going to have to.
Right, he says it's not him, he wants something else.
Well, did I inquire as to why he thinks it's not him, Your Honor? He said it's fake. I want to
Your Honor,
understand.
the question's been answered.
It doesn't, if he said it's not him, it doesn't matter why he's saying it's not him. He's saying it's not him. If you can prove otherwise, that it is him, then that you're entitled to do that.
Thank you.
The defense questioned the witness about an audio recording where he reportedly made statements about the altercation. The witness denied that the voice on the recording was his, leading to further scrutiny. The cross-examination then shifted to a civil lawsuit that the witness had filed against Mayers, in which he claimed assault and emotional distress.
You were struck by a bullet, projectile, or fragments which required you to seek necessary medical attention. Is that true?
That's correct.
Now, you understand that's different than what you told the police in this jury, that you believe your hand was raised.
Your Honor, this would be sustained.
Now, you assert that the projectile that hit your hand, according to your civil suit, required you to seek necessary medical attention.
Your Honor, it's improper impeachment. This is a civil suit. So on a final step. Any further questions? What the causes of action are, the jury has heard. That's the relevance of it.
I don't want to run afoul of the court's ruling. I want to ask, there's another question I want to ask regarding the permanent damage alleged. What is that?
Your Honor, our position would be, stop. You can ask him if he has any permanent damage. It doesn't matter what it says in there.
No.
Is there any permanent damage as a result of the injury received supposedly on November the 6th?
Your Honor, just make you have no objection to any questions of the witness regarding his knowledge of what he's doing. Our issue is going back to what is in the complaint.
Right, I agree.
Thank you, Your Honor.
I agree.
So my question, if I could follow the court's guidance. Has this incident caused permanent physical damage to you?
Yes.
Okay. What is the permanent physical damage that it has caused to you? Forget about the lawsuit.
I mean, just look at it. I like to live in hell. Besides me doing what I'm doing, I can't really.
Okay, that's not what he's asking. Ask again.
Sure. What is the permanent physical damage that this incident has caused to you? The permanent physical damage?
No, there's no permanent physical damage. I just was hurt that on a moment.
The defense pointed out inconsistencies between his testimony and the lawsuit, particularly regarding the extent of his injuries. The witness initially claimed he required medical attention due to a bullet fragment, but under questioning, he admitted that he had not suffered any permanent physical damage. To further dispute the claims, the defense introduced social media evidence, showing a social media post of the witness's hand.
Permanent physical damage. What would be the relevance of this photo?
You weren't ruled yesterday about the relevance.
This is also July of 2022. What would be the relevance of this photo?
The objection is overruled. It can be shown to Mr. Evans.
Okay. That's obviously your hand, right? Sir?
Okay.
It was okay, then yes.
Sure.
Okay. And that's the left hand that was injured by the shot?
By the grades, yeah.
By the grades. Do you see, as you sit there, do you see any
I mean, I can go around and show everybody right now. I still got it 3 years later. I'm showing from a far picture. I still got it. No, I can't see it right there. I can't see it.
They argued that the post showed no visible signs of lasting injury. The witness insisted that the effects of the incident were still present, but acknowledged that any visible damage might not be obvious in the photo.
People of the state of California versus Joaquin Mayers, case number BA 508142-01. We, the jury in the above entitled action, find the defendant, Joaquin Mayers, not guilty of the
Cannot get the audience. Or you cannot get the audience.
Hold down, hold down. Verdict has to be read on camera. Yes, sir. Repeat again. We, the jury, the above entitled actions, find the defendant, Joaquin Mayers, not guilty of the semi-automatic firearm in violation of Penal Code Section 245, Section B. A felony is charging count 1 of the information this 18th day of February 2025, jury seat number 9, 4 person. All right, title for the cause. We, the jury, in the above entitled action, find the defendant, Joaquin Mayers, not guilty of the crime of assault with firearm in violation of Penal Code Section 245, Section B. A felony is charging count 2 of the information this 18th day of February 2025, juror seat number 9, 4 person.
During this trial, I watched you periodically. You did what we asked of you at the very beginning, which is to give both sides a fair trial, pay attention, use your common sense, apply the law, and base your verdict on the evidence. I know you took extensive notes, and you took this as seriously as any jury could. We cannot have jury trials without folks like this.
After nearly 4 weeks of testimony, the jury deliberated for approximately 3 hours before returning a unanimous not guilty verdict on February 18, 2025. Mayers, visibly relieved, expressed his gratitude to the jury, saying, "Thank y'all for saving my life." He was embraced by Rihanna, who had been a constant presence throughout the legal battle. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.